Good afternoon, this is Sean Golding with Golding & Golding, here to review the offshore voluntary aspect of the IRS Voluntary Disclosure Program. So the Voluntary Disclosure Program has been around forever, and for a few years, there was an offshore specific offshoot of the program called OVDP, or Offshore Voluntary Disclosure Program. They've gotten rid of that program, and then the international and domestic components are both part of the main VDP, and the program's morphed for the worse, unfortunately, over the past few years. So why don't we talk about some of the important components and aspects of a voluntary disclosure in 2024. So the reporting requirements. Individuals and other domestic entities have certain reporting requirements to disclose their foreign accounts, assets, investments, and income. It may be reported on they may have to report like foreign bank accounts, investment accounts, other types of financial accounts, pensions, life insurance, mutual funds, ETFs, all that kind of good stuff. There's various different reporting forms that taxpayers have to file. Some of the common forms are the FBAR, Form 8938, Form 3520, 5471, 8621. The forms have different threshold requirements. For example, the minimum threshold requirement for the FBAR is more than $10,000 on any given day of the year, whereas Form 8938 starts at $50,000. There's different due dates. There's different ways to file for an extension, and some forms even have an automatic extension like the FBAR. So when you mix this up in a pot and you put this kind of requirement on a taxpayer, it's overwhelming and it's not fair. But for some taxpayers, they don't qualify as non-willful. Willfulness in the realm of FBAR and offshore reporting is not just intent. There is willfulness, there is willful blindness, there's reckless disregard. So if you cannot certify under penalty of perjury that you're non-willful, then you don't qualify for things like the streamlined domestic offshore procedures, streamlined foreign offshore procedures, delinquency procedures, making a reasonable cost statement. You don't qualify for any of that. So instead, you have to do the voluntary disclosure program if you're going to do anything. But if you're continually willful and you don't file, you're getting yourself into a real tax fraud, potential tax evasion type of situation. The program's been around for many years. And again, if you're doing offshore or domestic or both, it all falls under the moniker of VDP, Voluntary Disclosure Program. So what are a few key facts, about the offshore aspect of voluntary? The reason I keep saying offshore aspect of voluntary disclosures, there's a separate VDP program for ERC and related stuff. This is just talking about offshore disclosure for people who are willful under the voluntary disclosure program. So first thing is there's a 50% penalty on the highest year's maximum value. So you go back 6 years, and 1 year you had $3 million of assets, 50% penalty is $1.5 million. In general, the IRS is not very willing to negotiate that penalty. They were more back in the day because you could technically opt out of OVDP. They don't really have that as part of the voluntary disclosure program. They see it as, hey, over the past 5 to 10 years, it's become more of a criminal issue in terms of the IRS enforcing it. And so we're giving you this ability to not have to go to jail or prison by submitting to the voluntary disclosure program and paying a 50% penalty. Obviously, the taxpayers don't see it that way, but that's the IRS's position. There's also a 75% penalty based on the highest income tax liability for the income with the highest year in that 6-year period. Basically, one fraud penalty and one FBAR penalty. Now, in prior versions of the program, OVDP, some taxpayers who were non-willful would still submit to the program. So history-wise, when OVDP first started, it was for everyone, and then they developed the streamlined filing compliance procedures, which is a non-willful offshoot of OVDP. But some people still wanted to do OVDP because, you got in compliance for 8 years instead of 6 like it is now, and you get a closing letter and you're not going to get audited for any of these issues, and the penalty wasn't as obnoxious as it is today. These days, you would not do the voluntary disclosure program if you were willful. Why? Because you have to sign a statement under penalty of perjury that you are willful. They don't want to hear people pussyfooting around the idea that, maybe they're non-willful, things like that. in these days, if you're going to do the voluntary disclosure program, it's for people who are willful, okay? And typically it's for people who may be at risk for criminal enforcement. Another thing that some taxpayers don't like, it's not as big a deal as some people make it, is that as part of the Voluntary Disclosure Program, VDP, you're subject to an auditor examination. Now, if a person only has offshore issues, it's typically not a big deal. It goes normally 30 to 90 minutes at the most. You're on there with your attorney. Typically, you would hire someone who's board certified, and they're on the phone with you, and it's not a big deal. But if you also have domestic issues, it can get a little bit more complicated, because as part of the voluntary disclosure program, even if it is primarily or all related to offshore, if you own your own business and there's issues regarding prior year stuff that the IRS may not think is necessarily kosher, they can delve into those issues. So essentially, you're opening yourself up, you're opening the tax returns up beyond just the offshore component for the prior years, and you're doing it as part of an auditor examination. So there could be some direct questioning. So this is something to be aware of or cognizant of if you're thinking about doing the voluntary disclosure program. But for taxpayers who are willful, and especially those who may be potentially subject to a criminal investigation, it's still 99% of the time it's going to be better just to pay the penalty and go on with your life. We're one of the few firms where we specialize exclusively in this area. We've represented thousands of people in all these different types of programs, and for the most part, they almost always feel better regaining their peace of mind after the submission process is done. We've got a ton of free information available on our main website and our sub-website. You can always reach out and schedule a reduced fee initial consultation about offshore disclosure if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.